case briefs, and so much more. LSData's got what you're looking for.
In the 1991 Supreme Court case of Florida v. Jimeno, the central question was whether a suspect's general consent to a vehicle search included the officer's ability to examine closed containers inside the car. The case arose when police officer Frank Trujillo stopped Ennio Jimeno's car following a suspected drug deal overheard on a phone. Though Jimeno agreed to let Trujillo search his car, he later argued that this consent did not extend to the paper bag in which drugs were found. The trial court initially sided with Jimeno, but the Supreme Court ultimately ruled that Trujillo's search of the paper bag was reasonable, based on the belief that Jimeno's consent was broad enough to include it. Chief Justice Rehnquist wrote that the Fourth Amendment permits an officer to examine a closed container if it is objectively reasonable to assume the suspect's consent covers the container in question. The court further held that a suspect's consent to search a car includes the authorization to inspect closed containers that might conceal drugs. Officers are not required to make separate requests for permission to search each container, and the discovery of evidence inside a container based on the officer's reasonable belief that consent was granted will be admissible in court.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsc.law, elevate your mind. Leave the stress of class.